And so with respect to exclusions, let's start by talking about so-called deceptive matters. And that takes us to the In Re Budge manufacturing case. And so here we have a refusal to register the mark Lovey Lamb for automotive seat covers, the reason being that the Trademark Trial and Appeal Board concludes that lamb is deceptive because the term lamb suggests that these goods are derived from animal products, but the goods themselves are actually synthetic. They do not, in fact, have animal products in the seat cover. And the standard for determining whether or not a mark is deceptive is to ask first, is a term misdescriptive of the character, quality, function, composition, or use of the goods? If so, are prospective purchasers likely to actually believe that the misdescription describes the goods? If so, is the misdescription likely to affect the decision to purchase? And so what is the work being done by these requirements, right? The first one is the term misdescriptive of the character, quality, use, composition, etc. If it's not, then if it's actually descriptive, then we have a different problem, right? We have a descriptive mark and we know we need secondary meaning, but registration is still possible. If so, are prospective purchasers likely to believe the misdescription actually describes the goods? That's important because what do we have if we have something that is misdescriptive, but nobody thinks it actually describes the goods? Well, that would be an arbitrary mark, wouldn't it? So if you have Apple computer, nobody thinks that the apple is descriptive of the computer, that it's made of apples, it smells like apples, or goodness knows what. But of course, it's a fully registrable, protectable mark because it's arbitrary. Nobody thinks there's a connection there. And then finally, is the misdescription likely to affect the decision to purchase? This is the concern of materiality. And so we don't want consumers actually being led to purchase something that they otherwise would not, but for believing that the product has the quality in question. And this is distinct from a deceptively misdescriptive mark, which trademark law says, okay, this is a situation where consumers believe it, but it's not material, but we still are going to require secondary meaning, but there's not going to be an absolute bar to registration. So back to the Lovey Lamb case. Is the requirement or is the standard for a deceptive mark met here? Is the term misdescriptive of the character, quality, function, composition of the goods? Yeah, it is. The goods are synthetic, and the term lamb suggests that we have something made of animal skins, in context. Are prospective purchasers likely to believe it? Yeah, right? Seat covers can be made from sheepskin and lambskin, and so purchasers may tend to believe that this is one of those products. And so will this affect the purchasing decision? Well, it turns out that natural skin products are more expensive, and so there may be a perception in some segments of the consumer market that having something that's made out of animal skin is of higher quality or has certain desirable qualities, and that therefore may affect the decision to purchase. And so one of the arguments made by the applicant here is this: look, our advertising is truthful, but the court makes an important point, and that is, look, one of the things that trademarks do is they function as these receptacles of meaning. And one of the values of that is that a consumer can look at a mark and bring to the product the associations one has with the mark. And so if that is going to work, there's going to be cases where all you've got is the product and the mark, and you don't have all the other advertising stuff. And remember, one of the efficiencies of trademark law is that you can have various forms of inputs that are all symbolized by a particular mark. And you can then encounter just the mark and let the mark stand in for whatever of that constellation of inputs the consumer happens to have been exposed to. And so that falls apart if we expect the consumer to, sample certain parts of this larger constellation at all times. And so it makes a certain amount of sense that the court would discount the existence of truthful advertising on the part of Lovey Lamb. Now, I alluded to this before, but just to kind of make sure it's clear, we have this distinction between deceptive and deceptively misdescriptive marks. And so under the Lanham Act, deceptively misdescriptive marks can be registered so long as there is secondary meaning. A deceptive mark under Section 2A can never be registered no matter what, no matter how much secondary meaning may actually exist. And so the distinction between a deceptively misdescriptive and a deceptive mark is that the PTO applies the first two prongs of the Budge test. Is the term misdescriptive? Will purchasers believe the misdescription describes the goods, but there is no requirement of materiality. And so if it's not material, we have a deceptively misdescriptive mark. If the deception is material, then we have a deceptive mark.